Well, all right, kids, here we go. Not only is it the final video lecture from all the major Supreme Court cases, not only is it the final video lecture from Unit 3 on the Supreme Court and the court system in the United States, it's actually the final video lecture, period. So let's hear some brief hoorays, hooray, stop the film, pop the champagne corks, etc., etc. Remember that you've got your sheet all ready to take notes on. Again, you can do it by hand or you can electronically mail them to me. Once you finish this final one, the whole thing should be done. So send it to me, share it to me, however you wish to do it. And there is, of course, going to be also an explanation of the Supreme Court Conversation Project. That's coming up separately, but that's not really a video lecture per se. So with no further ado, I want to mention that we're moving now into the 1980s. Generally speaking, from the 50s, 60s, 70s, you had the Warren and Burger courts that were fairly liberal, that saw the court as being an agent for change in the United States. The court began to severely protect the rights of individuals, perhaps even people who had committed criminal acts, but who perhaps had not had the proper procedure followed. Also, civil rights legislation was pretty major. And really, you can make an argument that the civil rights changes, the rights of African Americans and other racial minorities and religious minorities in the United States, you can argue that's the court's doing because the federal government, Congress, and president essentially did nothing for the previous 100 or so years. 1981, Ronald Reagan, a very conservative Republican, takes charge. He appoints a couple, 2 and I think 3 Supreme Court justices. There have been some Democratic presidents, Barack Obama and Bill Clinton, but they're sort of more middle-of-the-road Democrats. We definitely have a more conservative Supreme Court today, that's for sure. Let's take a look at about 12 of these individual cases. Plyler v. Doe, 1982. Well, the state of Texas, where I used to teach, had a law that prohibited the use of state funds to educate any student who was not a citizen of the United States. Now, I taught in Austin, Texas for 6 years. A number of the students that I taught were so-called illegal immigrants. Their parents had not come in a documented form. Interesting, my own take is that often these were some of the most compliant, hardworking, sincere students I had. Now, a lot of them didn't have terribly strong English, but by God, they recognized the opportunity that they were getting. So generally enjoyed teaching these kids a lot. John Doe, he was a child and therefore, like with TLO in last times, TLO is coming up, excuse me, the name not named by name for privacy reasons. Here's the question. Does the law deny them the protection of the 14th Amendment? This is equal protection, equal treatment. Well, but he's not a U.S. citizen. Court ruled 5-4, and you've got to guess with a couple of Reagan-era judges, probably would have ruled in the other direction, that the law did violate the 14th Amendment. And in the opinion of the court, a lot of the discussion said, look, we're looking at the 14th Amendment. No persons may be denied equal protection. It does not say no citizens. So the state of Texas and other states around the country, the precedent has said, we educate illegally dwelling in the United States children. Now, my world, that makes a lot of sense because these people are going to be here. You want them educated. You want them having some opportunities, etc. But again, that's where the court stands, but that's something that certainly in the Trump era we are seeing backlash against. Yeah, here's our other minor, TLO. I actually do know her name or have known, but I'd forgotten this. She was a 14-year-old girl who was caught smoking at school. Well, administrators opened up her bag and they found, yes, marijuana and other evidences of drug use and possibly sales. Now, here's her question. You can probably already guess what she argued. There was no warrant to search her bag. Is that allowable? And I should say under the 4th Amendment, which is search and seizure, then applied to the states through the 14th Amendment. Here's our ruling. 6-3, not unanimous, but they argued that this search without a warrant is permissible when A, there is reasonable suspicion. And of course, there's some danger with that because a person in power can call anything a reasonable suspicion. And this is the key, and I think probably a stronger argument here the majority had. that it's not just simply about this individual's 14-year-old's rights, but it's also the idea of maintaining order and safety in the school. And if you were to say, well, a little marijuana in her bag, did that really put other kids at risk? I would say probably not. However, if you think about the wave of school shootings, there is a reasonable suspicion that a young man, it's usually a young man, has a weapon in the locker. Would it be reasonable in the interest of maintaining order and safety in the school? There was a case a couple of years ago in South Carolina, just absurd, where the principal brought in people with guns, fake guns, ablazing, attempting a complete shutdown of the school, grabbing kids, putting them up against a locker, searching them. It was all a prank, or not a prank, but a drill, but obviously incredibly inappropriate. So again, that reasonable suspicion gives a lot of leeway to some pretty unsavory people. But 6-3 decision, and it stands still. Bowers v. Hardwick, real interesting case. An Atlanta police officer had entered Michael Hardwick's apartment. He had gotten a warrant for his arrest for drinking beer in public or something silly like that. Actually, Michael Hardwick had already paid that court cost, but something was lost in the city offices. Well, the officer came to the door, knocked, no one was there, came into the apartment and found him having sex with another man. Now, these were two adult men, two gay men, and this is what they're doing. Georgia had what they call an anti-sodomy law. Sodomy is, Sodom and Gomorrah from the Old Testament. Generally, it's kind of a loose term, but basically means oral and or anal sex, and doesn't have to apply only to two men, although that tends to be how it's enforced. It shouldn't say so. That's a mistake. It should not be Bowers was arrested. It should say Hardwick. That was a typo. It turns out that Hardwick and Bowers are both named Michael. Michael was, I think, the Georgia Attorney General or something. But note that that should say Hardwick was arrested. Well, this is a privacy case. And the argument, although again the word privacy does not appear in the Constitution, does the state of Georgia have the right to regulate consensual sexual behavior between two adults? Court ruled 5-4 that the state of Georgia law was valid. And it's interesting. I've read over this decision before, and it's pretty hard to defend. I'm of course paraphrasing it and putting it in Zeker language, but in effect, you see the decision of the court saying, well, it's not really the state of Georgia's right. I mean, after all, these are grown-ups doing what they want in their own home, but I'm sorry, this freaks us out. We can't deal with the fact that two men might be doing this. There were very, very strong dissenting opinions. The 4 justices were very, very clear. This simply wasn't the state of Georgia's business. But in fact, the conviction was upheld. Michael Hardwick, who we know, by the way, died of AIDS a few years later. You'll see a later case, Lawrence v. Garner, in which this has changed. But this was the precedent for the next 17 years. It was okay for a state to specifically criminalize homosexual behavior. Again, not in public and not involving youths, involving adults. Another free speech case. This one's actually kind of fun. Matthew Fraser was a public school student. Well, I assume somebody will do this as part of our Supreme Court conversation, so I'll kind of leave this at this, but basically gave a speech at his school. He was introducing another student and making not even vulgar words. He wasn't dropping F-bombs, but he made a number of clearly sort of inappropriate sexual jokes, etc., etc. The school said, Mr. Fraser, this is wrong. You are suspended from school. Well, Matthew Fraser, as you could tell, was sort of an individualist young man, and he said, wait a minute, I think my constitutional rights have been violated. And you can probably figure out this is a First Amendment case. Yes, he was a student, but of course, going back to the Tinker v. Des Moines case, students don't, you can perhaps put some restrictions upon the student's rights to speak or behave as adults within a school situation. We saw that in TLO versus New Jersey. On the other hand, you've also got the precedent Tinker v. Des Moines, in which the young people were allowed to express themselves. Here's our court's ruling. Ruled 7-2 that they had the right. Again, this is probably, well, it is a more conservative court by 1986. And again, the question is, was this disruptive? Do schools, because they are protecting, they are taking care of lots of younger people, do they have more leeway? This is the type of speech that if I were to give in public, I could not be arrested for. There's very little ability to do that. But in a public school, because there are other children around, the argument was that, yes, this was disruptive. It stopped the learning process. It was a valid thing to suspend him. Another First Amendment case. Actually, this happened at an event I was at. I was at a public protest in Dallas, Texas in 1984, and I might have even witnessed this because I did see somebody burning an American flag at this protest. I don't know if it was Gregory Johnson or not, but I did in fact see somebody at that very same protest. Somebody had given him an American flag, and he set it on fire. He was sentenced to prison because there was a Texas law. There are always Texas laws, aren't they? Against quote unquote vandalizing of respected objects. So Gregory Lee Johnson is the litigant. He is the guy that says, wait a minute, my constitutional rights have been violated. Clearly, First Amendment. That is a form of political speech. It may not be a speech that would make an American patriot all that happy or somebody that reveres the flag, but if this is something that he wishes to do, is that not just simply a way of saying, I don't appreciate or agree with this country? Want to point out that he did not steal it from a government office. That would be a whole different thing. That would be violating, vandalism laws or theft laws, etc. 5-4 case, and you notice these cases are getting a lot closer, that to criminalize the destruction of a flag specifically because it's a flag is a violation of First Amendment rights. In other words, it was overturned by the highest court in the land. There has been a move for some on the political right to have flag burning or destruction of the flag to be a new constitutional amendment. That would be the 28th Amendment. It has never gotten particularly close to that. But any laws that would simply say specifically burning an American flag, that is an unacceptable form of expression. Right now, the precedent stands pretty strongly that is not something that the state or government of any sort can do. A complicated one, particularly sad, Cruzon versus the Missouri Department of Health. Every parent's worst nightmare. 26-year-old woman named Nancy Cruzon was an automobile accident. In a permanent coma, simply is not going to survive. You could probably, if you were in AP Psych last year or this year, you'd know that her medulla, her reticular formation were destroyed. She was not going to be able to survive without an artificial respirator, without a feeding tube. There was absolutely no chance of her surviving. Her parents asked that these tubes, this medical equipment, be removed. She should be allowed to die. In other words, Missouri cannot force life-maintaining treatment. Missouri argued that no, Nancy Cruzon, if she were to suddenly wake up or if she had left behind a written will, a living will, she could make that decision. The parents couldn't make the decision themselves. The litigant, actually, it is the parent's name, I believe the father's name that appears on it, but it's really Nancy Cruzon's so-called right to die. So here's a question, and this is a tough one. Can relatives make a right to die argument for a terminally ill parent or a non-responsive family member? And this is tricky because on one hand, you could say life must exist, life must continue. On the other hand, what if it's a life that by all standards are not worth living? Nancy Cruzon, if she were alive today, she would not still have in any way recovered. She wouldn't be able to breathe on her own. She wouldn't be able to be conscious. And of course, there are matters too about the cost of this and also the difficulty of being a parent or a family member and feeling this horrifying obligation to continue to go see your daughter who you love dearly, who you mourn every day, not getting any degree of closure. On the other hand, we can see the idea of could somebody make a right to die decision irresponsibly? Well, another tight court case. 5-4. An individual can do this. But notice the language. The state was not wrong to not allow the relatives to make the decision. Notice the way that's worded. Now, this is not directly from the decision of the court, but it didn't say the state was right and this could never happen. They said, in this case, we're not willing to overturn what the state of Missouri has done. Therefore, Nancy Cruzon she kept the feeding tubes, were kept in her. She did die a number of years later. I forget the details behind it. What we do see, though, now is that people have living wills, probably something I should get myself, in which you say, well, if the doctors have deemed that I've had a massive brain hemorrhage and there is zero chance of recovery, etc., what do I want to do? I had to make that decision with my mother. The doctor showed me the brain scan and said, look, she's had a massive hemorrhage. I hate to tell you this, but there is absolutely no chance of her recovering in any way. And I made the decision pretty quickly with my wife, Shara, to remove the tubes, that I didn't see a need to keep her alive in a vegetative state for a week, a month, a year, etc. And I'm very confident this is what my mother would have wanted. But again, you want to spell this out as much as it's not fun to think about ahead of time. This is kind of a key case, and you're definitely seeing a newer Supreme Court here. San Antonio 12th grader Alfonso Lopez was charged with having a firearm in a school zone. The state of Texas had made this a considerably harsher penalty. It's one thing to be carrying a firearm that wasn't registered, but to have it in a school zone. Well, here's the question. Was this a constitutional law, or did Congress overstep its jurisdiction? You might remember that there was the Commerce Clause. And remember, although I didn't include this in the list of cases, but I probably should have, we've talked about it before, the Heart of Atlanta Motel case of 1964. And it was ruled in that case in 1964 that a hotel owner, private property, could not deny people of color, could not deny African Americans the right to stay in his hotel. Why? Because he accepted guests from other states and he bought supplies from other states. Therefore, Congress had the right to impose a law based on the Commerce Clause that could regulate them. This was the argument that Congress made, the United States government made here as well. In this case, the court, and I don't recall what the vote was, but Congress ruled that government had failed to prove that it had its power. They argued that the gun could be covered, the government said, by the Commerce Clause in Article 1, and the court said that's not valid. The fact that the trigger of the gun or the gun itself might have been made in another state, that's giving too much power to the state. So again, you're seeing the courts by the mid-1990s, after 12 years of Reagan and the older Bush, well, you see the courts becoming more conservative, more business-friendly, less regulation-friendly in general. So Alfonso Lopez's charge was overturned as a result. This would have been 2010, I believe. I'm sorry I didn't put the date here. But there was the so-called BPCRA, the Bipartisan Campaign Reform Act of 2002. And we have already had some limitations on campaign spending. I believe it's in the 1970s. I think I mentioned this in the last unit. If I want to contribute to a presidential candidate's campaign, I can, in one election cycle, donate about $5,000. Individuals can do that. What we started seeing, though, is that various entities, and very often it's corporations, big companies, big businesses, because they have the money. They can also be labor unions and other organizations. Well, we're not going to donate money directly to a candidate. What we're going to do is donate money to a cause, to an issue, to putting together a film, an informational film that very clearly attacks one candidate and supports the other. It's not a direct campaign contribution. Well, this law of 2003, and it was co-written by a Democrat and a Republican, hence bipartisan, put an end to this, put a real limit on it. A group called Citizens United, I'm sorry I didn't finish the slide, I put it together, but it was a conservative activist group. They argued that a film that they had made, which was quote unquote nonpartisan when Hillary Clinton was running for president in 2008, they did not donate money to her opponents. What they did, though, is they produced and released a film that really attacked Hillary Clinton. I mean, brought up a lot of terrible things, a lot of which is probably not even valid. Well, here's the question: spending money on that film, releasing that film, even though it's not going to another candidate, should that be illegal under the Bipartisan Campaign Reform Act? Notice another 5-4 decision. And by the way, it's justices promoted by, nominated and appointed by Democrats, voted against. The 5 in favor voted voted with the majority. The Supreme Court ruled that limiting types of spending like this for corporations or unions was a violation of their First Amendment right. In other words, corporations, Microsoft, Amazon, they have rights of free speech as individuals do. And in effect, as long as they're not giving more than $5,000 to an individual candidate in an individual election, they can really give as much money as they want to. We saw some city council races in Seattle, Washington, where Amazon is located. Amazon, by the way, owns Seattle. Something like, and I wouldn't recognize Seattle, I used to live there. Amazon owns something like 30% of the property in downtown Seattle right now. It's taken it over. Amazon is thought to take in about $1 billion a week in new wealth, which is just absolutely insane. Well, they decided that they didn't like the city council in Seattle. It was a sort of a left-wing city council that was trying to put some restrictions on businesses. Now, Amazon as an entity would donate the whatever, a couple $1,000s they could to individual candidates. But altogether, they donated $1.5 million. Now, this is in a city council election, 7 small elections, to an organization, to a pro-business organization that produced informational materials. But these informational materials were clearly working against people on the existing city council. Amazon appears to have gotten some of what it wanted. It did win a couple of the seats, but was rejected by others. But we are seeing now, because of this Citizens United case, we are seeing almost unlimited spending on elections. Michael Bloomberg, the former mayor of New York, who actually was elected as a Republican, but has moved toward the Democratic Party, he said he's going to spend over $100 million in 2020 to influence elections. Sheldon Adelson, a very conservative Republican, has spent more than that. And Charles Koch and his brother David, who died recently in Kansas, I think I've mentioned that in 2016, their goal was to get $1 billion spent in elections, not just to candidates, very little of that to candidates, but to citizens advisory groups, to pro-business groups, that it's very clear the type of work that they're trying to influence. For my money, the American democracy is not going to work if there's unlimited money in it. And I don't think that's a partisan issue. I don't think it's good for Republicans and bad for Democrats in the long run. I just think it's a disaster. There is a movement perhaps to turn a campaign finance regulation into a constitutional amendment, or wait for the courts to change their mind. Although given the fact that 2 new ones have been appointed by Donald Trump, that's probably not happening in my lifetime. So we'll see. A fairly major case. Graham v. Florida. Terrence Jamal Graham was convicted twice of armed robbery and assault. At the second trial, again, he was 17 years old, he was sentenced to life in prison without parole, meaning he could never, ever get out. He lives to be 85. He will die in prison. Terrence Jamar, I thought it was Jamal Graham, is the litigant. And here's the question. Well, I guess I'm sorry, I didn't do an issue for this, but is this a violation? Is this a cruel and unusual punishment? Again, with the 14th Amendment bringing the 8th Amendment to the states. And in this case, the court looked at this and said, sentencing a minor, somebody who committed a crime when he was 17 years old, didn't kill anybody, violates the 8th Amendment's injunction against cruel and unusual punishment. The legal age in which someone can be tried as adults very different in different states and different countries. In the Philippines, Rodrigo Duterte, who is their law and order president, my wife and I think a pretty horrible guy, he was suggesting lowering the legal age to try people as an adult to the age of 9. A child 1 year older than mine committed a certain crime could be tried and sentenced as an adult. Later came out that when he was 13 years old, he sexually assaulted one of his maids, but oops, oh well, never mind, this applies to other people. But that's always a question. What do you do? At what point are you an adult? Is it 18? Is it 17? Is it, as Duterte thinks, 9? Is it 20, etc.? But ruled in this particular case that he was too young to be sentenced to life, although had he murdered somebody, it might be a different case. Got about three more for you, I think, here. Snyder v. Phelps, and this is hearkening back to Brandenburg v. Ohio. U.S. Corporal Matthew Snyder was killed in Iraq. There is an organization out of Kansas called the Westboro Baptist Church, who I don't know how else to put it, but these folks are nuts. They argue that God had turned against America because America was allowing homosexuality and immoral behavior, and therefore Corporal Matthew Snyder, who, by the way, was not gay, was not a homosexual. See, this is God's punishment. So what the Westboro Baptist Church people is they have gone around the country, and when a soldier's funeral is held, they show up with signs in effect saying, "You deserve it." One of the signs that they will hold up is "God hates fags. You're dying because of America's sins." Now, first of all, it's just unbelievably ignorant and hateful. And imagine the poor parents trying to say goodbye to their lovely son, the son that they'll never see again. And you got these people out there not in the funeral home. They're in a public space, on the sidewalk, on the road, and that's important to note, standing outside in effect saying, "Your son deserved to die because America has gone wrong." It is the family of Matthew Snyder that holds this case. And look, nobody with a soul, nobody with any sense of compassion would argue that this type of free speech isn't offensive, hurtful, just inexcusable. But is it protected by the First Amendment? And the court ruled 8-1, including language saying, "We don't like the speech of the Westboro Baptist Church, but they are conducting their protest in a public space, and they have the right to do this." So an 8-1 rule, the Westboro Baptist Church was allowed to continue these protests. I'd mentioned the Dollery Map case. This is in 2014 in California. A young man named David Riley was pulled over. There was a traffic violation, ran a red light, and handguns were found in his car. Now, the police had an ample reason to search the car. That had been determined by previous court cases. But they also picked up his cell phone and began to look inside it. So David Leon Riley, here's the case. The cell phone. Now, what does the U.S. Constitution, the Fourth Amendment, specifically say about rights to privacy with your cell phone? Well, it's funny. Founding Fathers really didn't get around to dealing with cell phones, with mobile phones. Court ruled in this case, unanimously, digital information, that doesn't exist in a real place. It's not actually you can touch, cannot be searched without a warrant, the same as a physical house. But this is a major test case because so much of our lives are digital now. We do have some digital rights in cases like this. So any information found on that phone was excluded from his trial, part of the exclusionary rule, basically an updating of Map v. Ohio a little over 50 years later. Oberkfell v. Hodges in 2015. I did not see this coming. Again, you know that I would consider myself very gay and lesbian friendly, that as far as I'm concerned, if two people fall in love, hey, good for them. A couple of states a number of years ago, about 10 years ago, I think Hawaii and Massachusetts first, began to allow same-sex unions. They allowed two men or two women to get married. Now, you recall that one of the obligations that states have is that if you have a contract in one state, it must be recognized by others. So if I buy a car in Florida and I drive to Georgia, I still own that car. That's understood. The state of Georgia can't say we don't recognize that contract. My wife and I were married in Florida. When we go to Alabama, I try to avoid Alabama, but to Alabama or to California, we're still married. We don't need a new marriage license. Well, these two men, James Oberkfell and John Arthur was his husband's name, were married in Maryland where it was allowed. They went to Ohio, they moved to Ohio, and they were told, no, we don't allow this in the state of Ohio. So here's the question. Did the state of Ohio refuse was it forced to recognize the due process clause, the equal protection clause of the 14th Amendment? After all, the Constitution does say, it's very, very clear, if this had been a man and a woman, the state of Ohio would of course recognize them as a married couple. Were they being discriminated against? Were they being denied equal protection because they were both men? 5-4 law, 5-4 ruling. All states must recognize same-state marriage licenses granted in other states. And this is currently the law of the land. I have a number of friends from years past who actually have gotten married to somebody same sex. I've attended a couple of these marriages. Again, a 5-4 vote, that's something that could be turned around. There is a talk in the political right of limiting marriage to one man, one woman, etc., etc. But at this point, this is the law of the land. And again, something I would not have seen growing up in high school or even in the 80s, 90s, or early 2000s. So a fairly major change in the United States, and it's happened in many countries around the world as well. And I believe there is one more case, maybe two more. So if I suddenly cut off, it means that we're done. Again, send all of this. Once you've done all of these court cases, send your notes in to me, and we'll follow up from there.